So let's say we've resolved all the jurisdictional issues, we know what substantive law is going to apply, and now it's time to get the ball rolling. The defendant, what the plaintiff does to start his case is draft what's called the complaint. It's basically a laundry list of all the stuff that happened, followed by a request for money, an injunction, or some other court intervention, demanding that the defendant do or not do something. The complaint is organized as a series of numbered paragraphs, each paragraph containing one and only one allegation. Typically, the paragraphs are short, one sentence approximately. The allegations need not be true. They are, after all, just allegations. The plaintiff only needs to have a good faith basis to believe that the allegations are true, or, if he really doesn't know, there just isn't enough information at this point to indicate one way or the other, he has to so indicate on the plaint, usually by saying something like, upon information or belief. Here's an example. Paragraph 27. John was wearing a red shirt on the day that he attacked me. Paragraph 28. Upon information and belief, John didn't brush his teeth that day. Obviously, the plaintiff doesn't really know whether John brushed his teeth, but you can kind of guess. The complaint has to name all of the parties, both plaintiffs and defendants, and explain why they're relevant to the litigation, who they are, make clear from the complaint who the relevant parties are. And it must name all parties that are indispensable to the litigation. That is, all parties that have a direct financial interest or a legal interest in the outcome of the case. It also has to specify a basis for subject matter jurisdiction, whether arising under diversity jurisdiction or supplemental jurisdiction. The basis of subject matter jurisdiction for each claim has to be specified. If the defendant is relying on diversity jurisdiction, he must state the amount in controversy, or when he doesn't know exactly how much is in dispute, because that's going to be resolved during discovery, he must state that the amount in controversy is more than $75,001. After all, if it isn't, there's no diversity jurisdiction. If the plaintiff wants a jury trial, he must demand one on the cover of his complaint. If he forgot to do so, he can correct it by amending, which we're going to discuss later, or serve a separate notice of jury demand within 14 days of filing. The complaint's most important function is to put the defendant on notice of the plaintiff's claims. That means that it must clearly state the plaintiff's basis for the lawsuit and must specify the relevant facts that support each of the elements of each of the plaintiff's claims. So for example, if Mike sues John for negligence, he must allege the facts that satisfy all of the elements of a negligence claim. He must have facts that speak to duty, breach, causation, and damages, the 4 elements of negligence. Mike does not have to say that John had a duty of care because the rules are not so formal. All he has to do is allege facts that specify a duty of care. For example, if it's true, all Mike has to say is, John is my father, or John is my employer, or John was otherwise responsible for my safety, or something else that indicates that in fact John had a duty of care. The complaint can be as long or as short as the plaintiff wants, as long as he states his claims and adequately supports them. Sometimes it's good to be brief. Other times the plaintiff will want to tell his story at a very early stage in the litigation. There's no word or page limit, which gives the plaintiff a great deal of discretion, a great deal of freedom. That said, the rules require that the complaint be short and plain. If language is so flowery, redundant, or poorly written that the defendant can't figure out what it means, he has not been placed on notice, he has no idea what the lawsuit's going to be about, and the complaint will almost certainly be nixed by the court. Once the complaint is done, the plaintiff files it with the court. The filing does not put the defendant on notice. In fact, unless the plaintiff tells the defendant about the complaint, or the suit is otherwise covered by media, the defendant probably won't even know about the filing. All the filing does is open the case with the court. The filing date is the date that the suit began for certain procedural rules and nothing more. The defendant does not have to respond to the complaint unless he is served by the plaintiff, or a plaintiff's agent, I should say, as we'll specify in a minute, with the complaint in a court-issued summons. From the time that the plaintiff files his complaint, he has 120 days to serve the defendant with both complaint and summons. If the 120 days pass, the case will be closed. The plaintiff can file again if he wants to, but he loses any benefits he had from the earlier filing date. He's starting from scratch. When the plaintiff files his complaint, he asks the court to issue a summons for each defendant. The summons, when served on the defendant, gives the court jurisdiction over that defendant and compels the defendant to respond to the complaint. It is the court, not the plaintiff, that compels the defendant to respond. Read Federal Rule of Civil Procedure 4A. to see what information must be contained in the summons. Most importantly, it must have the name and address of each defendant, of that defendant, there's one summons for each defendant, and tell him how much time he has to respond to the complaint. Typically, that deadline is 21 days. Within that time, he must either file an answer or a motion to dismiss, which we're going to discuss both later. Read Federal Rule of Civil Procedure 4E to see what the plaintiff must actually do to serve an individual defendant. In brief, he must have someone else hand deliver it. We don't allow the plaintiff to do it himself because we're afraid that the plaintiff is going to be smacked in the face when he does. Have someone else hand deliver it. Have someone else leave the complaint at the defendant's home with someone of suitable age, not necessarily a young child. Excuse me, not a young child, but maybe a child would be okay if the child is of suitable age. Or send the complaint by a certified mail return receipt, or doing anything else permitted by the state law. That is, contrary to the rules of Erie, well, that's not entirely true. The federal law incorporates state law. That is, state law is directly written into the rules, so you're not going to use Erie here. If none of that works, there are instances in which the plaintiff can simply publish the complaint in the newspaper, or have someone else nail a copy of the complaint to the defendant's property. But these are only an option when the defendant is being evasive and upon court order. You're never going to assume that these are an option unless there's really no other option. Finally, read Federal Rule of Civil Procedure 4H to see what the plaintiff must do to actually serve a business entity. In a nutshell, any officer or managing agent of the organization can accept service on behalf of the corporation.